Okay, everyone, it is September 22nd, 2021, and this is the Brilliance in Commerce Natural Law Trust webinar with Randall Hillner and Dominique Hackett joining. I'm Tonson. So thank you for joining us. Let's get going. As you may know, Brilliance in Commerce is a project of La Verite, which is the truth in French. And House of Freedom International Natural Law Trust is our topic today. We also have Liberty Debt Elimination System and a lot of affiliations and other types of offers. We're members of the Worldwide Charter for International Commerce, and we invite you to look on the website to read more about that and see our certificate and the principles that you can see displayed on the right there. Today, September 22nd, 2021, our next trust webinar with Randall will be November 17th, and that is anticipated to be the last one of the year, although those of you who are paid trust clients have the privilege, the special privilege of Dominique's monthly trust webinar study group. For those who need it, a phone number is 360-200-7521. Is our company number. It's generally a voicemail. We get back to everyone. And for those who need it, house-of-freedom-trust.com is a generic site. But if you have someone who has introduced you, we prefer you work with them and go through our rich body of appreciated affiliates. My name is Tonson Fairmont. I'm the founder. I'm a consultant in bank instruments programs, speaker on a lot of shows in the past, and chief cook and bottle washer and all kinds of things. So Randall is our fantastic head of the illustrious trust department, the entertainment for today. And House of Freedom Trust is a design, a creation, a compilation, or a formation after decades of study with some of the world's best mentors, and created by Randall and his body of knowledge that goes back all the way to the roots of common law and the UCC and so forth. He's the founder of White Light Unlimited, trustee of One People's Public Trust, and our speaker today. Dominique is joining us today, and she works with Randall and myself. And she's got a nice background, as you can see, with our trust as well as statutory entities, corporations, accounting, fundraising, and radio shows and so forth. So Dominique, thank you again and again and again for joining us. We really appreciate your presence and your assistance. We have a couple of comments saying there's no sound, but others are saying that yes, the sound is perfect. So anyone who's writing into chat, if you can help those who have no sound, where to click to find it. We have a topic today of a recap of the June webinar, Duty of Loyalty, Part 2. And so for those who missed it, or for those who then benefit from having Randall go over it again, we're going to review that and then just blend right into friends and loyalty, the theme for today. So very good. Randall, I'm going to ask you to unmute and go ahead and ask you to speak.
Aloha, everybody. It's good to be back.
Start your video.
Oh, that's right. Got to have that too.
There you are.
Okay.
Beautiful.
A little older and wiser than a couple of months ago, but still having a good time in life, as I hope all of you are. I hope everybody is healthy and wealthy and enjoying the summer. So we're going to go over, even though I watched Dominique a couple of weeks ago, because I had missed it. I was gone for a bit, and she did a great job. And I just want to run over those bits and pieces some more, and also give me a sense of how it works. And then we can blend it into friends and loyalty. So first, we have the duty of royalty. And then you go into friends and loyalty. And we're going to touch upon what happens when the loyalty isn't there, or there's a breach of contract in the trusteeship of what you're doing. I know that a lot of you have chosen to be trustees, and it's a critical, that's the most critical part in the play that we do. And the more you learn about the aspects of what it's like to be loyal and what it's like to be in a breach, then the better off you're going to serve your beneficiaries. So I guess with that, we'll start with some slides if there are any, or I can read my script, whatever you have. Oh, what a surprise. Ah, yes, fiduciary responsibility, conflict of interest, and breach of trust. This is all summaries, a summary of the principle of trust law in this area by this people over in Europe, where it all really started in England, the law of trust. And the information comes a lot from that source, although I have the American versions of it, which is maybe a little bit different in wording, but the essence is the same. Fiduciary responsibility is what it is, and that's what we're going to hold to. And if you are being a trustee or want to become a trustee, then it'll be good for you to pick up the principles that we're going to talk about today. So we have a flip screen so that we can get into the first quote, or you want me to read off my notes? Oh, there we are. That's quite the house. Jeez. Needs a haircut. Well, welcome, folks. A little humor to start the show. A director or trustee acting as such has a responsibility to his company or to his client. So whether you're going to be a trust for your own trustee for your own family trust, or whether you're taking on the role of a trustee for a larger endeavor, or you have a project that you're about to start and you want to make sure that if you are going to be the trustee, that you're grounded in the principles so that you know where the guidelines are, you know where to find the guidelines. I think we've posted it before, but on Townsend's website, he does have my bibliography. I try to keep it updated as much every time I find something that's has any value that I feel, just brings another piece of the pie together so that we get a more conscious pie. So the bottom line is that it's good faith, and you're doing the utmost you can to make sure that this vision, the vision of the grantor, sometimes you know the grantor, sometimes you've been chosen by the grantor to be the trustee, but the vision that he has set forth in the trust is something that you need to work with. So that is fairly simple if you work within the guidelines. In other words, you make sure that you know the trust, you understand it, you read the trust manual, you read the book that Townsend has written. There's a couple of books on the bibliography that are worth reading. If you want to get into the law, then you can touch bases with me, and I'll set you up with all of that. But it's not that kind of a heavy, complicated anchor. It's not an anchor. I want you to look at trusteeship as riding into the wind and filling your sail with wonderful results. So self-interest and avoidance of conflict of duty and not being in breach are three of the principles that we want to stay away from. Okay, next slide, please. Yes, a requirement to avoid conflict of duty. It's precluded from obtaining for yourself or anybody is in close hands for any kind of property or business endeavor that you have participated in, and yet the trust, you want the trust to participate in, but you need to make sure that if you are setting up a particular process, whether it's a long-term contract, short-term contract, anything like that, that you as trustee need to not do it or put a piece of that in your own pocket. Let's take that out, expand it a little bit and say that you as a trustee, the way we've written the trust, is you're allowed to have a salary for the work that you do, commensurate on the amount of work that you do, the time spent, the value that you have. But outside of that, your job is to make sure that the trust assets stay healthy and that the beneficiaries also benefit in the highest regard for what you're doing to in whatever that contract is. It could be a short contract. If you look at the trustee powers, you're going to find significant, especially if you've got our trust already. You should know all of those powers specifically. They're expansive and they can take you wherever you want to go, but you need to go in the right manner. Okay, next slide, please. Oh, if you want, okay, so when you sign your contract with this trust contract for the client, whether you're the trustee and you either know the client or you're going to get to know them pretty quick, you have the right to resign. But the idea is you don't want to take this job lightly. You want to make sure that you step in, and if you're going to be the trustee, you want to look at it as a long-term basis, because down the road it's going to benefit you, and you're going to become very, very, very close with the people that that you work with, and that you're the trustee for that particular trust or company or whatever it is you do. We have a lot of people that have already have a business and they're moving their business into the trust. A lot of people just beginning and starting out. A lot of people have investments and they want to assign them to the trust. So we have a number of places, number of schedules within the trust document where you can assign certain aspects of those assets. So personal property, you might have valuables that you want to assign to the trust. You might have gold and silver, you might have cryptocurrency. This can all go in one schedule. If you have real estate, it's going to go into another schedule. And if you have foreign currency, then it's even separated out more into another schedule. And your job as trustee is to make sure that there's sufficient bookkeeping done to keep that in alignment. I think the thing I like about Dominique so much is that she's actually here. She's intending to write a book on how to do trustee expenses. And so I think she's setting that up. So that'll be available either with private consulting with her, or she may be putting on her seminar through us to help do that. You want to know those, how to keep expenses clean, how to keep all the assets separated, how to have them correctly done into a ledger book. And the better paper trail you have, the better your trust contract will stay together. Okay, next slide, please. Oh, we're in a movie set now. Well, okay, so even after you may, fiduciary responsibility does not continue after determination of the relationship which gives rise to it. In other words, the trustee is in a general but not a continuing operations which is the feature of a fiduciary relationship. In other words, you have a hat you're going to wear as a trustee. And then when you take that hat off, if you're in another part of the trust process, then you have to take the hat off and not work as a trustee, but work as either a beneficiary or as a settler or as a separate contract altogether. So you have to be really careful, especially if you're holding two hats. If you might be the grantor and you might be a trustee, but you know the beneficiary. You need to make sure that when you do trustee work, that you are really clear that it's your trusteeship that's important. And if you're being the settler and you're writing the vision, then you need to make sure that that's what you're doing and you're not stepping on the toes or doing anything that belongs to the beneficiaries. Okay, next slide, please. Okay, acts done by the trustees while in contract of the trust subsists, which are preparatory to competition after it terminates. Okay, now this is critical too. This could cause a breach in the trust. If you have contracted with something and the contract is over, but on the outside of that contract, you still may be benefiting from it, then that could be a conflict of interest and could cause a breach in the trust. So it's really important to make sure that that you really keep those hats separate if you're wearing more than one hat. And that's loyalty and fidelity and friendship as well. Okay, slide please. Because as a trustee, you're going to acquire a lot of knowledge, especially if you're at it for any length of time. And so if they do leave, if your trustee does leave for whatever circumstances there are, he may choose to resign. You may choose to alter the way the trust works. And he can take that knowledge skill with him. In fact, that's an important aspect. Every time we write a trust, we gain more knowledge every time. It's like I write 2 or 3 trusts a week, 4 trusts a week. Every time I do that, I'm going right through the trust to make sure not only that everything's in place, but that I'm understanding more and more and more. All of that knowledge keeps coming out every time I read the trust. That's why it's really important for me as a mentor is to make sure that the client continues to, just don't go close your trust book and forget about it for a year. I want you to go and read it every once in a while. And if you have questions, go to the trust book and the manual first, and then come to us and ask specific questions. And I work really well with specific questions between client and myself. So as long as you're willing to do the work and read the text manual and the trust itself, then I just welcome any kind of questions you might have. Next slide. Oh, that's a long one. That's if he resigns, whereas resignation may fairly be said to have been prompted or influenced by a wish to acquire for himself any maturing business opportunities sought by the trust, where his position with the other company rather than his own, then that is going to include or become a breach of trust. In other words, you can't take information that you've gotten from a business or a participation that the trust has had in one business and then take it and jump outside of where you are as a trustee and take that position into the next one. Now that's going to create a breach of trust, because you've broken the loyalty and the friendship is going to wither with it. Okay, next slide. Okay, the underlying business of a liability of a trustee who exploits after his resignation of the company is that the opportunity is to be treated as if it were the property of the company in relation to which the trustee had fiduciary duties. So when you're a trustee, you're under contract to that trust and to that business and whatever it expands into. Please be really aware that even if you resign from the contract as a trustee, that you need to leave any proprietary information where it goes. Sometimes you might even have to sign a non-disclosure depending on the company. But whatever you do, whether it's with a company or it's on your own basis, you have a word. Your word is your truth. So be true to your word and take your fiduciary responsibility as it should be, and keep it sacred. Then you'll always be wanted as a trustee. Okay, next slide, please. Well, this is just a thing that got in there because what happens is the common law is so different from how the British trust law was established that sometimes it's hard to categorize what might be an opportunity and what might be breaking the security of that loyalty and breach of trust. So please just make sure that everything you do for the trust is kept in the trust book and not given out or abused in whatever way, that can happen. So the more aware you are of the good business practice of loyalty and truthfulness, then you'll be fine. Okay, that's another one.
And this begins your new theme, friends and loyalty.
Oh, okay. So, okay, so it's an inherent, the jurisdiction to authorize payment for a trustee. My mentors a long time ago got away from the fact that a trustee is a lifelong job that you do for free. And so we started to put phrases in where the trustee, the trustee power, one of the powers the trustee has is that he can be paid for his work. This is an extension of what we just talked about. But the idea is, if you're doing an honest work as a trustee, doing the research, make sure the trust minutes are up to date, that the business that the trust is in is being looked after, that really gives you an opportunity to be remunerated. And remove, I can't pronounce it, remuneration is how, is actually the correct spelling for being paid for being a trustee. And so since we've been doing it for a while, and the courts have come to realize that trustees, yes, trustees do deserve to be paid, especially nowadays that there are a lot of trustees out there, or a lot of lawyers out there that are doing trustee work, which unfortunately puts your trust in a statutory process. But the courts now favor the trustee be paid more commensurate on how much he does, how long he spends on doing things, how much time he spends taking up minutes, and maybe even running the business. Some trustees I have are actually doing the business. So they have a business to run, and they also have the fact that they're a trustee. So there's two responsibilities there. One is to the business and one is to the trusteeship, so that the loyalty and the the contract can be fulfilled. Of course, here it says also that you can get more than what's specified in the indenture. So it's basically what you want to do is, as a trustee, is to make sure that you do the right thing. You learn how to be a solid trustee, and you make your word true. Next slide, please. Okay, now, so here we have a little bit of what's authorized and what's not authorized. Say you do have a business going with that you've gone into an endeavor where the trust goes into contract to create a business. Now, what happens is, if by chance, if you're not careful, then you need to, there may be an increase. You may realize a profit from that. And that's one of the first things that creates a breach in trust, is if you take a unauthorized profit, a commission. Let's say you get a commission by directing a trust business to a particular company. If you haven't been authorized to do that, then you really, that's going to create a possible breach of trust. And you have to be very careful about that. Also, this is an example. X is a trustee for ABC, accepts a commission of $200,000 from an opposing side to secure a settlement in a legal action, and the court said that he had basically received a bribe. So if you're doing things that or looks anything like an authorized act of accepting money for being the trustee, then you need to account for that money, have it go into the trust, and not be using it for your own pocket. Next slide, please. Okay, the self-dealing rule and the fair dealing rule. This is where these are two critical things. The self-dealing rule makes voidable any transaction in which a trustee purchases the trust property or sells his own property to the trust, unless the transaction is specifically authorized. The reason is based on a no conflict rule, having an interest or duty on both sides of the transaction. So if you set something up and it goes well, but on the side you're pulling a little funds out, or getting some of the shares, then that's very inappropriate. And it's like stealing from an employer, your employer. You're stealing from the trust, and we don't want to do that. We want to keep the trust healthy. Now, in the fair dealing rule, not to the purchase, but to the beneficiary's interest in the property. So if a trustee purchases the beneficial interest of a beneficiary, he must show that he did not rely on his position, and he's given all the factual information to the beneficiary, and the beneficiary has decided that he doesn't want it anymore, and so he sells his beneficial share to the trustee for a fair price. So as long as the beneficiary knows that he has everything he wants, and he just wants to buy out of that particular trust, then he can do that. As long as he gets a fair deal, and that's a fair dealing rule. If he didn't get that information, then that's where the self-dealing comes in, and the trustee could be in breach of contract, breach of trust. Okay, next slide, please. The proprietary and personal nature of liability to account. A trustee's liability is the recognition that the property is trust property in his hands for which he does not account Included in trust accounts is the addition to the trust fund so that the beneficiary's claim is a claim to specifically enforce the trust over that property. It is not the trustee's property. The trust owns the property, has full lawful and legal title to whatever property's in there. And the trustee, even though he has that lawful right, he owns it on paper, but he doesn't own it for himself. He owns it for the benefit of the beneficiary. And then you got to be really careful on being really clear whenever you're doing a trusteeship that everything you do is accounted for. That's why I keep saying every time it's an action or there's a possibility of an action to be taken and a decision has to be made, that the decision and all of that is written down. Write it down, it becomes a paper trail, and that way you always know that it's been above board. That's the cleanest way to keep the trust safe, is to have a good paper trail, minutes for everything. And if you're doing minimal business, then maybe all you need to do is make sure that every time you get a monthly bank statement, then you have all of the activity, the financial activity of the trust for that month, and that should be held in its own folder. And every month so that means at the end of the year or whenever you have a trustee meeting, you can present those statements to the board of trustees or to the beneficiaries. Okay, next slide, please.
And ladies and gentlemen, you can begin writing down any questions you may have and getting ready for the question and answer session coming up soon.
Who is the principal we owe duty to? Is that what you're asking, Dominique? The principal, if that's correct, then the principal is the beneficiary. Okay, it says a wise and knowledgeable trustee who knows that friendship and loyalty and right action keep the trust in a safe and profitable manner for himself and more specifically for the beneficiaries. There's that answer you were looking for, Dominique, I think right there. So trustees, even though they have legal and lawful title to property, they have it in trust for the benefit of the beneficiary. I think that's filling up. So that means that questions are ready to be posted, if you have any.
Oh, yeah. Thank you, Randall. Everyone, just if you're calling in by phone, press *9 if you want to speak. And if you're on the computer or smartphone, you can click on the raise hand icon or use chat. Type in your question in chat. And Randall, I think that there's a principle in Sanskrit called seva. And that just means selfless service. So basically, another purpose of the trust besides asset protection, it would seem, is to train us to be of service to others, because we're basically holding these assets on behalf of the beneficiaries and doing our best to increase them, to protect them, to maintain them, to grow them, and to pass them on, and take some fair amount of compensation along the way, according to the agreement written into it. So it's really basically very simple, but it's a good training in helping others. Yes.
Absolutely. And again, it's a service. You will be chosen. You may choose to be a trustee yourself, or you may be chosen. And the payment is minor because it's the service that you're doing for the beneficiary, for the settler, and for the small community and the business that it's holding. The trust is holding a business. That's where the service comes, and that's where the payment comes in your new the people you meet, the work you do, that's your, as you say, seva. We say service. That's the uniqueness about it.
And Dominique has asked, what is undivided loyalty? If we are trustee and running the business, do we have divided loyalty? Should we only be paid as trustee?
Divided loyalty means if you take gains from the business for yourself or you place them in another spot that don't have anything to do with your initial one, then that you're not being loyal to the trust. So the loyalty comes by only doing work for the trust, and it should stay with the trust, and your loyalty would stay with the trust first. Did that help, Dominique? You got more to ask on that?
In other words, 100% of the business compensation would go to the trust, and then the fair amount agreed upon for the trustee's compensation would come back to the trustee, right?
Yes, whatever has been agreed upon.
Yeah.
Absolutely.
So it's pretty simple.
Well, it'd be, let's say it's the running of the trust is very similar to running a business. You have a storefront where you have your product or your service out front, and then you have your back office where you have your financial process happening. And what you want to do is you make sure that the service in front is equitable to the profit that comes in back, and that the beneficiaries receive what their fair share is based on the ratio that was initially set up with a trust, and what you have contracted with the settler or the other trustees. Now, that doesn't mean that those things can't change. The way things go, the trust may be more profitable, be less profitable. The idea of the equitable trustee is that he's going to give the beneficiaries the most appropriate ratio percentage that keeps the trust intact and keeps the business from going bankrupt. So that's why we have discretionary powers for the trustee, because sometimes there isn't enough money that particular period of time to pay the beneficiaries, and the beneficiaries may not be paid for a year even. But if it, in the end, when the business comes back or the equity begins to expand again, then those beneficial interest can be paid out at that time. It's an ebb and flow. It's just like running your own personal business or your own personal life. You don't take money out of your right hand to pay your left hand. You wait until you can afford to have money in both pockets. Okay.
Ocean asks, there are some new people in this audience who are hearing about trust for the first time. They may not be familiar with the terms grantor, trustee, and beneficiaries, and who can fill those positions.
Sure. The grantor, in most cases, the grantor is the person that wants to create the trust in the beginning. Now, or you can be that person, you can be the grantor. And like I have clients who are the grantor and the trustee, and the beneficiaries are his children and grandchildren. So he wears a hat as a grantor. He creates the trust. He sets up who he wants as trustees. He sets up the percentage rate of what goes to the beneficiaries. And then he steps in the role of being a trustee. He runs the business as he wants to, and he has the discretion to give the beneficiaries either more money or less money. It can pay for the education of the children and grandchildren. There are numerous things that the trustee can do, and the idea is to make sure that you just have a paper trail for that. So that's the grantor. Then you have a trustee, one trustee or two trustees or three. There's sometimes if it's big enough, you might have 3 trustees, and then you don't have to have a unanimous decision on an action to take. When you have an odd number of trustees, then you just need a majority. So we usually work with 2 trustees, but I have clients who are just a sole trustee. Now, today, the banks want you to have, if you're the sole trustee, they want you to have a successor trustee, because the banks don't like to be trustees themselves. So we have, if you are going to be a sole trustee, then you have to have a successor trustee. Then the beneficiaries can change all through time. Maybe the children have children, and it just goes out and out and out, and all you see the names of Kennedys and Rockefellers and how many multiple trusts they have, because the estate is so large that you start to break it up. So in the beginning, there may be 3 children, and then all of a sudden they have 3 children. Then you might want to have an extra trust in there so that some of that estate can be broken up and it's all decided, and it just keeps expanding and expanding and expanding. My question?
Okay. Oscar asked, what is the best way to transfer an incorporation to the trust?
S Corp. An S Corp can be, in other words, the trust can be the owner of that S Corp. You transfer or you assign the ownership of your S Corp to the trust, and then the trust would run it, and it would be out of your name. Now, you may or may not be a trustee. You may want to go on to something else, but in the meantime, that trust and that S Corp will continue to grow. Same with an LLC. Oftentimes, some people have a trust and they want to do another business. And so rather than create another trust, they'll do an LLC, and the LLC will be owned partially by the person and partially by the trust that's already established. It's a choice, and the percentage ratio can change as you want. So it's a lot of variables, but that's all you need to do. Now, oftentimes, if your trust is on the smaller side, or if the estate or assets are on the smaller side, more than one trust is not needed in the beginning. But once it starts to enlarge significantly, then that's when you can think about another trust. Or if you have more beneficiaries, or you want to break a part of it off to give to a different endeavor, you can do that as well.
Okay. Ocean asks, what is the difference between a statutory trust and a natural law trust?
Statutory trust is usually within the system. In other words, if like you have a lawyer have as a trustee, then it could become a statutory trust. Or if you register with the state, it would be a statutory process. Also, if you connect it to an LLC, it may be a statutory process. So in order to be out of that system, you want to keep it between people who are not involved with any statutory process, a banker, a lawyer, anything like that.
Yeah, Ocean, the ebook explains that more in detail.
Yeah.
And Raina asked,
Go ahead. Go ahead.
Raina asked, can you be grantor and trustee?
Yes, you can be the grantor and be the trustee, but you can't be the beneficiary. Or you can be you can have a nominee grantee. That's one of the services we offer, BIC offers. And so then you could be a trust, you could be one trustee, and you could be a beneficiary. That's really not encouraged. It's very restrictive. So those are the 2 hats you don't want to wear at the same time. You can, but you have to be very distinctive in what you're doing as trustee and how important it is to keep a paper trail if you do that. I don't encourage it at all.
Would a simple way to answer that be that you could wear 2 out of the 3 hats, but never all 3?
Yes.
Yeah.
Other questions?
A lot of questions coming in, Randall.
Good.
Ocean says, if the life insurance names the trust as the beneficiary, how do we as perform our duty as a trustee to make sure the funds are dispersed?
I'm sorry, I missed part of that, Townsend. Can you?
If the life insurance names the trust as the beneficiary,
Yes.
how do we perform our duty to as a trustee to make sure the funds are dispersed?
Well, that, if you have a life insurance policy, it would be like anything else. You have to disperse it. However, in other words, if life insurance is made out to the trust, then the trust would give that pro data ratio to whoever the beneficiaries are. So it would be dependent upon how the beneficiaries receive the percent of their interest. And that's what you'd have to do with the life insurance policy as well. You'd have to just use that same ratio.
In other
So if
words,
you have three beneficiaries in a life insurance policy would go to the 3 of them. And also the trustee would be able to take a small finder fee from that insurance rate as a fee.
right.
That's really, that's where your paper trail is really important. That if you get something like that, that the details are clear and strict.
Maybe another way to say it is that if you add 40, 40, and 20, it adds up to 100. So anything that is the percentage of the beneficiary's interest has to add up to 100%. So whatever the division is, according to beneficial units, let's say beneficiary 1 has 40%, second one has 40%, and the third one has 20%. Then whatever the assets are in the trust at the time of distribution, that's the percentages they each get, right?
That's correct. Boy, you've learned a lot in the time we've been together.
Well, I learned arithmetic.
Oh,
Rick asks, how do you use it for an S Corp? I thought there's a rule where an irrevocable trust cannot be an owner of an S Corp.
I don't know of that rule. I'd have to investigate that. But if it did, I mean, if the rule is that it can't own an S Corp, then you'd have to decide whether you want to dissolve the S Corp and just put the business in the trust. Or perhaps you could do it through an LLC. I'm not familiar with S Corp rules.
Well, we've had clients who've given portions of their S Corp, at least, haven't they? I mean, like up to 90-something% of the income or assets to the
Well,
trust.
we've done that with LLCs. So it's easy, but I never had anybody come to me with an S Corp, or you just sell it outright. You sell the S Corp outright to the trust, and then the S Corp can dissolve. You run
Yes,
the business through the trust rather than the S Corp.
no rule against that.
And that's true.
Oscar says, does the trust have to pay payroll taxes if there is an S Corp under its possession?
Well, I imagine payroll taxes, if anything close to statutory, then yes, would have to pay payroll taxes.
I would think that it's the corp that would do it. If the corp's still alive and functioning, then the corporation just continues paying those things. No?
You could do it that way, but usually if the S Corp can't be owned by the trust, then you would just have the trust do whatever it needs to do to take care of any kind of payroll tax.
Yeah.
If there's been a payroll tax.
I think the better thing to do would be for the corp to stay in business independently and take care of all those statutory requirements, and then just give a portion of its assets to the trust.
That's what I would do.
Yeah.
Potential profit
Yeah,
would
rather
go
than
to the trust, and then it's out of that loop.
Yeah, otherwise you're entangling the trust with all those statutory requirements.
Right. That's, again, you're getting closer to making it a statutory trust rather than non-statutory.
All right, JB says, what is the difference between a fiduciary trustee and a trustee? That's question number one, and then she has a second one.
There's no difference. It's just a fiduciary trustee is taking care of fiduciary responsibilities, and which is what a trustee does.
Right, just an adjective.
Yes.
Then she says, can you or should one be appointed an executor of an estate and a trustee of the trust, as well as a beneficiary of that same trust? Can you be all three?
I wouldn't suggest that, because then you're, well, if you have a fiduciary duty in the trust, then you don't want to be the executor unless it's totally separate. In other words, if the estate is involved with the trust and you're trying to be executor and trustee, then I say there's a conflict of interest.
Conflict of interest. Yeah. And number three, can you be confused as to being told not to be a trustee on certain occasions, like Munkin is a fiduciary trustee of your estate. So when is it best to be a trustee, and when is it best to assign trusteeship to someone else? Finally, with IRS going bye-bye, who are we accounting to as trustees other than the beneficiaries?
Yourself and the beneficiaries and the grantor. I mean, whether there's any IRS or not, I would definitely keep a paper trail.
That's
Because
just,
if the trust gets sued in any form, in any way, if something happens and something happens within the trust and there's the paper trail, then you're going to have less confusion than if you don't have any records.
absolutely.
That's basic bookkeeping.
Well, I've always said that if it ever happened that they brought the tax to an end, the trusts are still extremely valuable and absolutely have longevity into the indeterminable future because of the efficiency of estate planning and
Sure.
organization of assets for distribution.
Absolutely. There's no probate with a trust. There's nothing, and the trust doesn't end. In other words, people are going to end, they're going to pass through the trust, they're going to pass through life, and the trust can continue to go on. In case Rockefellers, Kennedys, people have had trust for long generations of time, and it just keeps the assets separate from the local community, not only financially, but physically as well. So if you don't own it, then you're not going to get in trouble for it.
Yep. Amarval asks, is the receipt of life insurance a taxable event? And Amarval, I will just say, and Randall, you can add whatever you like, that a better way to ask the question would be if the trust is the beneficiary of a life insurance settlement. Put the question back to you. Is the trust a taxable entity, and does it file reports when it's not required to?
No, it wouldn't have to. It only if it's a statutory trust and it's required to file, then it would file, or it would set it up so that any potential profit would be taken out first or gone to a different vehicle first, so that there isn't any taxable requirement. And even if we're not even talking about taxes, if the IRS goes away, you're still keeping that asset separate from yourself. Take the case of Kennedy when he drove off the bridge, because nothing he owned. He didn't own anything, so there's nothing to sue him for. I mean, if you own everything, then people will be looking for ways to take part of your estate.
So the answer to your question is that it applies to any kind of asset that's
Yes.
bequeathed to the trust, regardless of what it is. Paulette asks, how can we find a qualified attorney in common law? Is this the way to go to establish a personal will, etc.?
I don't know that you need a lawyer for a will. You can get them online for free. You have to make decisions on your own. And rather than use an attorney or somebody that's in a statutory process, you just need the witness signatures of two people, two witnesses that aren't related to you. That acts just as well.
Which raises the question, if you have a trust, would you also need a will?
I have both. And I keep my financial and valuable equity in trust. And I have in my will all those extra things that aren't worth putting in a trust.
You mean like your surfboard?
Yes, I don't put them in trust because I have my friends that are going to get them anyway.
And Ocean says, is it better to create a trust than a nonprofit?
Depends what kind of a nonprofit you're doing. If your nonprofit is a 501c3, then that's a statutory foundation. If it's a 508, then you're outside, you're doing a religious process, which is outside the statutory process as well. But I would suggest doing the 508 only if you really have a spiritual endeavor that you want to participate in and broadcast out to the public.
I'll share a personal story. A few years ago, I was invited to be on the board of directors of a 501(c) that was a kind of a it was a healing center in the Northwest. It was a kind of health organization with meetings and all of that. And I watched the chairman, was a lady. Oh man, the amount of bureaucratic red tape she had to go through. Unbelievable. She was having committee meetings and having to follow all these rules. And we had these board meetings and she had an agenda and we had to keep minutes and it just went on and on and on. What was the benefit? You don't get anywhere near the benefits as you would with a natural law trust.
That's correct.
A lot of fees, a lot of expenses, a lot of complications, a lot of regulatory red tape. And I think it's just ridiculous. It's not worth it.
It's the same with an LLC. It's a statutory endeavor. So you have to abide by the rules of that state that you have your LLC in.
Yeah.
I believe that's probably the same with a Corp, S Corp. A corporation, of course, is a statutory process. They were all created so that people could have some separation, but they didn't realize that they're all got sucked into the statutory process.
Oscar asked, do we still need a CPA if the IRS is gone? And
if you're not good at adding, yes.
Get a good bookkeeper.
Yeah. Hire Dominique.
Absolutely.
Actually, if she's going to have a program, I bet she's going to have a program. You plug it in with your trust document and your financial process. It's all taken care of.
Dominique, if you're listening, I ask you to unmute. Would you be so kind as to say hi to everybody and maybe address that?
Absolutely. Hang on one second. Let's see.
I haven't heard from you today.
Oh, wait, there. Ha ha ha. Hi. Wonderful seminar. Thank you. Thank you. So much love to you. So what we are working on in our trustees study group is I'm accumulating notes regarding fiduciary accounting, whether you're simply gathering up those bank statements and making some notes and then summarizing that at the end of the year in a trust minute. Really simple. And yeah, so I hope people will join us in our trustee study class once they have their trust, because we're having fun making sure that we all know how to do our accounting.
Not only that, you get a prettier face to look at.
And we don't call it accounting, actually. We call it trust financial tracking because it's very different than a business. It's very different.
I
And
like
so
it
we,
already.
yeah, we help people understand trust financial tracking.
So Oscar, we hope that helps you. Yeah. And you're writing a book on it, right, Dominique?
I am. I'm writing a book on it, and I'm completing a fiduciary accounting course, which I tell everybody the links to the course that I took. It's regarding statutory fiduciary accounting, but still, for people who are into double entry accounting and are running a lot of assets, it's very helpful.
Great. And then Rick asks, has there been any case where the IRS tries to tax a natural law trust? Do they ever question why the trust is getting so many 1099s and K1s?
Well, I've had years where I've had a lot of 1099s and I never heard from the IRS. So I don't know what to say on that.
I think that's pretty much the case with all our clients.
Yeah, it just depends on whether you've been filing all along and you're well versed, you're well hooked into the system or not. I don't think 1099s are the reason the IRS, because haven't had any clients come to me because the IRS is knocking on their door because of 1099s to their trust.
My own experience confirms that. I've had trusts with 1099s and never a peep or an inquiry. Okay, JB asks, why or how does a revocable trust become irrevocable at time of death? Is it automatic, Randall? Must there be some statement in the trust as to it being converted to an irrevocable, or is it assumed?
From the little I know about it, it's an automatic transition.
But that's not referring to our natural law trust.
Yeah, it's different. The revocable trust is written in such a way that upon the death of one of the partners, there's usually two settlors, that upon the death of one of the settlors, then it automatically becomes irrevocable. And that's so that person that's left cannot take those assets out of the trust. They have to stay in the trust then.
I can speak to this a little bit in California. You can go on to like Law Depot and you can actually look at a revocable trust document, and it specifically says that when the settler who created it dies, then there is a successor trustee that takes over, and that successor trustee is taking over an entity that is now called an irrevocable trust.
Right. And that's typically the partner of the settlers are typically married partners.
Yes.
This might be a good point, Randall, to say then why do we only write irrevocable trusts from the beginning?
Well, irrevocable trust is much more complex. And what we want to have that separation of assets immediately. With the revocable trust, assets is not separate from the partnership. So if anything happens in the partnership, those assets are all at risk. Whereas with the irrevocable trust, upon signing, you've immediately separated the assets from the beneficiaries.
Oscar asks, is it? Go ahead.
Does that make sense? Dominique, do you like that one?
I think that's a yes.
I love it. Yes, yes.
Got it. Thank you.
Oscar asks, is it mandatory to create an EID, I think he means EIN, number if the IRS is gone? And Oscar, really, that depends on the banks. It's just an ID number for banking purposes only. So it doesn't really matter.
Yeah, and that's right now, that's they demand that because the banks all belong to the IRS. So that's why.
Yeah.
I think in Europe, I've had clients in different parts of Europe and South America, and they have been able, they don't have the same number. They do have a type of tax number in Canada and down in Australia, but in some places they just use your personal ID for your passport into the bank account.
And Amaral says, please elaborate for the out of US listeners as to what a 1099 is. Amaral is from Canada.
It's just get it like you go into a store and you give them money and they give you a receipt. That's what the 1099 is. It's a receipt that their company gave you a certain amount of money because they don't want to take on any possible tax liability if there is any.
And normally 1099s are only issued for monies received over $600. So if you received less than $600, there's no requirement to file a 1099 by a company.
Right. Okay.
Thank you.
T4s in Canada. Awesome.
Okay, thank you, everyone. Any other news or thoughts, Dominique, while we're waiting to see if there's any other questions?
Sure. I wrote up some questions before before the seminar. Here we go, Randall.
Okay.
How do we, so I read a little bit about affirmatively proving that we've fulfilled our trustee fiduciary responsibilities. So I was thinking, are there certain words that we should use in our trust minutes that help to, provide, if we needed it sometime in the future, that is affirming that we have done our duty?
Well, I think that's what comes into play when I bug everybody about writing minutes, because it's a fact that you're writing a paper trail. It doesn't have to be explicitly some title or some term. I think it's just the fact that on this date, for the past month, this is what's been going on with the trust. Either there's been no activity, or there's a little activity over here, or a little activity over there. And this is affirmed by my signing this minute. That's your affirmation.
I love it.
That's your affirmation right there. I don't know that there's a term is needed.
And if the trustee does realize there's a conflict of interest, do they only talk to their co-trustee or their board of trustees? Or is there an additional requirement, especially if they're a sole trustee and they only have a successor trustee? Should they talk to the beneficiaries and document that? What do you recommend?
They've got to come clean. You've got to tell somebody they replace. Even if there was a profit made for the trust, that let's say that an endeavor was happening and the trust made a profit and the trustee took some more than he was required to get, he has to come forth and put that money, replace that money into the trust and pass it down to the beneficiaries. So whether there's a loss or profit, if he did not earn that compensation, it has to be returned to the trust. And, if it's more than once, I would say that you're not going to be trustee very long.
Got it.
That's why I call it friends and loyalty, because you're making friends with these people that you're working with. You become part of the family. And yes, it's a lot of it is business in a business sense. And when it gets big, it's going to be more business-like, but it still means that you have to be loyal to the trust, and you may have friendship along with it. But loyalty and no breach of contract, no breach of trust. Then you'll go. You'll have a good history.
JB says, where should one store their trust in the event of a natural disaster that wipes out a territory in order to preserve the trust? Who should you store the trust with? Perhaps on the other side of the country?
I think they're fireboxes. You're, for one thing, now especially, you can put it on a thumb drive. You can make multiple thumb drives and have them in different places. But usually, I mean, that's an extreme circumstance, I think. But typically, people have trustees in different places. So the trustees will have a copy, banks will have a copy, and can always document it electronically. Put it on the web. I don't think there's a need for that, but thumb drives, certainly, they're safe.
Mhm. What about beneficiaries? Should they have a copy of the trust?
It's a choice the trustees can make. They don't need one.
Okay.
All they have, the trustees have a right to know what's going on. And, but we also have a clause in our trust document that if the beneficiaries try to get too far into the trust, it's not their business, then we have the ability to cut them out of the trust and prorate their ratio to somebody else. So it's a no contest, non-contest clause, and that's specifically its own section in the trust document. It keeps the beneficiaries from being too noisy, too noisy, too noisy. That's if you're from New Jersey.
Julie writes, thank you, Tonson, Randall, and Dominique. With your seminars, vast information library, and the monthly trust meetings. Thank you, Dominique. I am slowly understanding trust, the minutes, the management of, and stepping more into sovereignty. Invaluable. Thank you again.
Yes, very good. Thank you for the question and response. I think it's great that people, this is a part that I like a lot because I give out certain facts, and then it's when people ask questions that I get to be, come alive and show some, okay, I'm not just reading this off a script.
JB asked, what if you want to change the beneficiaries?
That's your right to do if you're, especially if you're a settler.
Grantor, settler?
A grantor settler, yes.
In other words, under the trustee's discretion, it has to be in harmony with the original intent of the trust.
Yes.
Stacy says, how do I move assets out of an irrevocable trust into a new irrevocable trust?
Well, let's take the case of you have money in an account and you have a house and you want to take the house out of the money account. You'd create a new trust. You and the trustees would assign the house to the new trust. And one of the trustees can be trustee of the new trust, but there must be a non-related second trustee. Otherwise, you're not really creating a new trust. You need to have at least one new trustee.
So the trust indenture specifically speaks to the powers of the trustee being able to form new trusts for the benefit of the beneficiaries.
Correct. You've been reading your document.
Meaning that assets, if they fulfill the purpose of the trust under the trustee's discretion, can be moved out of the trust to another entity, as long as irrevocable means it doesn't go back to the grantor. It just
Yes. Irrevocable means that whoever put that asset in cannot take it out.
Right.
Cannot revoke it. You cannot revoke it. If it's irrevocable, you cannot revoke it. Whereas a revocable trust, it changes a little bit, but it still doesn't give you the asset protection that an irrevocable trust does, because it doesn't separate the assets from your pocket.
JB asks, isn't it best to put a house in an LLC and then have the trust buy the LLC?
No, I would create the trust. I would much rather put the house in a trust than an LLC. For one thing, the LLC is a statutory process, whereas
Yeah,
the trust is not.
no advantage to that. Besides, a trust doesn't purchase a statutory entity. It would only have perhaps some of the assets assigned to it from the
Right.
entity.
Right. Well, it can be it can be a percentage owner of an LLC. But unless you really want to keep that asset very, very separate from something else, you don't need it. I would stay away from LLC. I learned my lesson the hard way, and I had them, and I get to see that they didn't work in the long term because it was just too much in the statutory process.
Paulette asks, what type of orientation is useful for the Board of Trustees? The manual is helpful, but might not be understood. Do you have a video orientation on this?
Not necessarily. I would just read from the manual because and the bibliography. If you want to have more information, then I have a really excellent bibliography. And also you can start to tap into the knowledge of Dominique.
I'm going to put that on my list and create a little mini video and have you review it on how to orient new trustees. That would be fun.
Okay, we'll do
Yeah,
that.
and how to conduct a Board of Trustees meeting.
That would be fun.
Yeah. So thank you for the suggestion.
Yeah, perhaps that's something the three of us could do.
I love it.
Rick asks, if at some point the NLT wants to make a distribution to a beneficiary, will you have to prepare tax forms to them and the IRS?
It's a choice. If you're in the system, then you're going to be in the system.
I would really think that's the beneficiary's responsibility, no?
Yeah, well, it's whoever receives the benefit is liable
Right.
for any kind of tax liability.
Yeah. It's not the trust responsibility.
No.
Okay, everybody. Well, we had a fantastic exchange today, a nice conversation. Thank you, Randall, for coming back from summer vacation.
Yeah. What a summer it's been.
Yeah, and everyone. So we're going to have a lovely September remaining and October, and then meet again in November.
Next meeting's on my birthday.
Happy birthday, November 17th.
Oh, I'll have to join in.
We'll have to have some cake and everything on the webinar, you know. All right. We'll have a party.
We'll have cake and we'll eat it too.
We'll serve it right out through the computer. Okay, well, thank you, everyone. And we'll be concluding here for today. And those that look outside dream, those that look inside awaken. And intuition is the GPS of the soul. So cultivate intuition. Yeah. Any final comments?
Well, just always good to be back.
We appreciate you so much, Randall. Thank you so much, Tansen.
Thank you very much, both of you.
It's mutual, I'm sure.
And all of you that listen, thank you. And all of you that ask questions all the time, I really appreciate it. Don't worry, don't hesitate. Questions, just send them along.
Yeah, and of course, everyone, you may know that you can send questions in through our website or directly to Randall if you're a client, and to Dominique. Okay.
Thank you very much.
Bye for now.
Have a great one.
Aloha.
Aloha.
From Kauai.